I'm David Miller with the law firm of McCulloch Miller. At McCulloch Miller, we have over 40 years of legal experience in elder law, probate, and estate planning. Today I want to go into depth about something a little more technical, specifically capacity. Capacity is very important because it is the mental ability to sign or execute legally enforceable documents. In our practice of elder law, one of the main issues that we have to deal with is, does someone have mental capacity in order to sign important documents like, say, a power of attorney or a will? So I want to talk a little bit about what capacity is, when someone might have it, and other legal issues that are important. Generally speaking, for estate planning purposes, there's two different types of capacity. The first is testamentary capacity, which is the ability to make a will, and the other is contractual capacity, which would be able to sign powers of attorney or trust documents. Testamentary capacity is specifically defined under the law as the ability to understand the business in which the testator is engaged, the effective act of making the will, and the general nature and extent of his property, and also he knows the next of kin and natural objects of his bounty. So what does that actually mean? Well, it's very simple. It basically says for someone to have testamentary capacity, which is the lowest level of capacity, and again, that is the type of capacity you need to make a will, you need to know that you're making a will, generally have to understand what your property is, and you need to know who your family is. Another type of capacity is contractual capacity. Contractual capacity basically allows you to sign other documents like a power of attorney or a trust. And basically the standard is you have to have enough mental awareness to understand the type of document that you're signing. So for instance, with a power of attorney, you might have to understand every single word on it, but you would need to understand that you are generally allowing someone to act as your agent, that you're giving them certain powers, and know what those powers are. A common question becomes, when does someone have capacity? And so that's really important to know, because for a document to be legally enforceable, the signatory has to have capacity at the time they sign the document. This can be very important, especially for someone that's older or under medication, because they can go in and out of capacity. They might wake up in the morning, feel fresh, have breakfast, and have mental awareness and can be able to sign a document. But by the afternoon, maybe they're tired, maybe they've been medicated or sedated, and they no longer have that mental awareness. Then they go to bed that night and they wake up in the morning and they have capacity again. So what's really important to understand is you don't always have to have mental capacity, you just have to have it at the time you're signing the document. I'd also like to talk about some of the important legal issues around capacity, specifically the legal presumption of capacity. What that means is if somebody wants to say a document is invalid because the person that signed it lacked capacity at the time, well then the court is going to start with the assumption that the signatory actually had capacity. The person that wants to dispute that document bears the burden of proof. That means they have to show the evidence that the signatory didn't have capacity. And so that's really important when you're thinking about what happens if somebody signs a document, who can fight that document, and what they're going to have to show in order to fight that document. If you have questions about what documents your loved ones might need, or if they have the ability to sign them, please contact us for a consultation.